The city doesn't just grow by itself. It grows according to a set of plans which have a statutory basis. It's for that reason that lawyers are best placed to be able to argue according to the legislation how a development ought to be approved or how a subdivision ought to be approved where those applications are refused. A recent case that we completed was a case for a church that wanted to build in the Swan Valley, and they were refused development approval. We took their case through after it was referred to us by another town planning lawyer and argued it successfully and achieved the outcome that the clients needed. The area of town planning is a very interesting area of law. 20 years ago, when I started, we would argue cases before the Town Planning Appeals Tribunal. Today, we are dealing with matters in the State Administrative Tribunal, a specialist tribunal with lawyers as well as town planners who hear and determine cases. Having a good understanding of the processes of the State Administrative Tribunal and what is required to achieve an outcome and an approval for a client is very important. The only way within which you can properly take your case to the State Administrative Tribunal is where it's a question of a discretionary decision. That's the first point that we all always look at. The second is whether the discretion has been exercised properly and fairly, such that a reasonable decision maker ought to have properly exercised that discretion in that manner, or whether there's other ways within which that discretion was capable of being exercised. If that discretion was capable of being exercised in another way, we will work to achieve an outcome, either through the mediation process of the State Administrative Tribunal or the ultimate hearing process. But the first thing that needs to happen is that there is a refusal. Whether there's a refusal of the application or a deemed refusal, and that means after 60 days the application hasn't been approved, then we are able to run that case. A lot of people don't understand that zoning and questions relevant to a zone is not a question that we can take forward by way of an appeal to the State Administrative Tribunal. If a zone prevents a development, it is incapable of then being approved. Sometimes we have to take cases to the Supreme Court. That's where there's an exercise of judicial decision making. It's not a question of whether or not the discretion was exercised fairly and properly. It's a question of whether or not the local government has got the process by which it made the decision simply wrong. Taking a case by way of a judicial review out of the Supreme Court is available to clients. However, it's not an easy process, and we need effectively to demonstrate that the decision-making process was unlawful and improper before we can go to the Supreme Court. The legislation provides the framework of all planning decisions. Planning decisions are so important to the growth of this state. In about the early 90s, mid-90s, the emphasis in town planning moved to focusing on ensuring there was good environmental outcomes. As the available pool of good land to develop has diminished in Perth, as the environmental constraints over land has also caused the available land to be diminished, whether that's from a federal environmental perspective for black cockatoos or threatened ecological communities, or whether that is from the perspective of the state for wetlands, not federal wetlands, just ordinary wetlands. There are real difficulties now in people achieving or satisfying all of the different conditions that could be imposed on a development. I've been involved in complex town planning cases, representing and arguing cases in either the Town Planning Appeals Tribunal or alternatively in the Supreme Court where it's appropriate. Navigating through the planning system is very complex. There's been an increase in the amount of policy that is applied over the last 15 years to town planning decisions to an extent that's not really been seen previously. And policies are being given a greater and greater extent of weight. In the last 15 years, there's been a greater tendency of government agencies to say no. We are here to endeavour to achieve a good planning outcome for all persons concerned. Good for the applicant, good for the neighbours, and good for the community as a whole.